For the program to start, we need the blessings of Almighty. I request Akshita for prayer. Kindly raise for the prayer.
Vigneshwara Vinayaka Varaprasadiso Gajanana Shri Vigneshwara Vinayaka.
From darkness to light, let the inner self get enlightened with the light of hope. I, on behalf of Mangalore Bar Association, invite all the dignitaries for candling the lamp.
Good evening, ladies and gentlemen. At the very outset of this program, I feel I'm honored to take the floor to introduce the chief guest and welcome you all the August gathering. Our today's chief guest, Mr. Vikram Huilagol, hails from the family of a famous poet, dramatist, late Sri Narayana Huilagol, who created the song Udayavagali Namma Cheluva Kannada Nadu. Mr. Vikram Huilagol is the son of Dr. Ajit Huilagol, famous kidney transplant surgeon at Bangalore, and he has the credit of performing highest number of kidney transplant surgeries in Karnataka. Mr. Vikram Huilagol's mother, Dr. Medha Huilagol, was the chief anesthetist in Malya and Asia Columbia Hospital at Bangalore. Vikram Huilagol's brother, Sandeep Huilagol, and his wife, Pallavi Bogle, are also practicing as advocates at Bangalore. Mr. Vikram Huilagol studied law at Indian Law Society's Law College at Pune and later obtained LLM from Harvard Law School at Cambridge, USA. He was the additional government advocate and High Court government pleader from 2017 to 2021. Mr. Vikram Huilagol is a standing counsel on indirect taxes for the government of India. Mr. Vikram also served with the law firm King and Partridge Advocate at Bangalore. Mr. Vikram Huilagol was also law clerk from 2013 to 2014 at the office of Honorable Mark Law Senior Judge, U.S. District Court for the District of Boston, USA. Mr. Vikram Huilagol is the member the State Grievance Redressal Committee for GST, constituted by the Ministry of Finance, Department of Revenue, Government of India, and is also member of State GST Consultative Committee, Government of Karnataka. In spite of his busy schedule and other commitments, he has accepted our invitation with love and honor. His esteemed presence to this function has added colors to the celebration and doubled our joy. I extend a hearty and cordial welcome to you, sir. Now, I request our senior advocate, Sri Damodar, sir, to hand over a bouquet to our chief guest. The program, there is a better way, no better way of exercising the imagination than the study of law. No poet ever interpreted nature as freely as a lawyer interprets the truth. We have amidst us the Honorable Judge, the third additional District Judge, Sri B.B. Jakati, sir, as the guest of honor. We welcome you, sir, for this function. Now, may I request our senior advocate, Sri T.N. Pujari, to hand over a bouquet. We have got a charming personality with us, the president of this function, who is none other than the president of Mangalore Bar Association, Sri Prithviraj Rai. I extend a cheerful welcome to you, sir, and I request Mr. Vikram Padvetnaya to hand over a bouquet to the President of Mangalore Bar Association. And also, we have got the Vice President, Sri Manoraj, or the Treasurer, Mr. Shashiraj Kavur, the Joint Secretary, Chaitra, Ms. Chaitra. I extend a pleasing welcome to you all for this function.
I request Honorable 3rd Additional District and Session Judge, Mr. B.B. Jakati, sir, to address the gathering.
ನಮಗೆ ಈ ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದವರು ಪ್ರತಿ ವರ್ಷ ಈ ಒಂದು ವೆಕೇಷನ್ ಸಮಯದಲ್ಲಿ ಇಂತಹ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನು ಇಡ್ತಾರಂತ ಕೇಳಿ ಗೊತ್ತಾಗಿತ್ತು. ಆದರೆ ನಮಗೆ ಈ ಸಮಾರಂಭವನ್ನು ನೋಡೋದು ಇದೇ ಮೊದಲನೇ ಬಾರಿಗೆ. ಏಕೆಂದರೆ ಕೊರೋನಾ ಬಂದಾಗ ನಾವು ಬಂದಿದ್ದೀವಿ. ಕೊರೋನಾ ಆದ ನಂತರ ಒಂದು ವರ್ಷದಲ್ಲಿ ಯಾವ ಸಮಾರಂಭ ಆಗಲಿಲ್ಲ. ಇದು ನನಗೆ ಕೊನೆ ವರ್ಷದಲ್ಲಿದ್ದಾಗ ಈ ಒಂದು ಸಮಾರಂಭ ಏರ್ಪಟ್ಟಿದ್ದು ಅತಿ ಸಂತೋಷದ ವಿಷಯ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಇಚ್ಛೆ ಬಯಸಿದ್ದೇನೆ.
ಹುಯಿಲಗೋಳ ನಾರಾಯಣ ರಾಯರು ಕನ್ನಡದ ಶ್ರೇಷ್ಠ ಕವಿಯಾಗಿದ್ದರು. ಕನ್ನಡದ ಏಕೀಕರಣದ ಸಂದರ್ಭದಲ್ಲಿ ಇವರು ರಚಿಸಿದ ಉದಯವಾಗಲಿ ನಮ್ಮ ಚೆಲುವ ಕನ್ನಡ ನಾಡು 1970 ತನಕ ನಾಡಗೀತೆಯಾಗಿತ್ತು. ಈಗಲೂ ಕೂಡ ನಮ್ಮ ನಾಡಗೀತೆಯಷ್ಟೇ ಪ್ರಮುಖ ಅಥವಾ ಮಹತ್ವ ಹೊಂದಿರುವಂಥದ್ದು. ನಮ್ಮ ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಮುಖ್ಯ ಅತಿಥಿ ಮಿಸ್ಟರ್ ವಿಕ್ರಮ್ ಹೊಯ್ಲಗೋಳ ಇವರು, ಅವರ ಮೊಮ್ಮಗ ಎಂದು ಹೇಳಲಿಕ್ಕೆ ನಮಗೆ ತುಂಬ ಹೆಮ್ಮೆ ಅನ್ನಿಸ್ತಾ ಇದೆ ಸರ್. ಉದಯವಾಗಲಿ ನಮ್ಮ ಚೆಲುವ ಕನ್ನಡ ನಾಡು ನಿಮ್ಮ ಮುಂದೆ.
ಉದಯವಾಗಲಿ ನಮ್ಮ ಚೆಲುವ ಕನ್ನಡ ನಾಡು, ಬದುಕು ಬಳುಹಿನ ನಿಧಿಯು ಸದಭಿಮಾನದ ಗೂಡು. ಉದಯವಾಗಲಿ ನಮ್ಮ ಚೆಲುವ ಕನ್ನಡ ನಾಡು. ರಾಜನ್ಯರಿಪು ಪರಶುರಾಮ ನಮ್ಮನ ನಾಡು, ಆ ಜಲದಿಯ ನಿಜಿಗಿದ ಹನುಮನುದಿಸಿದ ನಾಡು. ರಾಜನ್ಯರಿಪು ಪರಶುರಾಮ ನಮ್ಮನ ನಾಡು, ಆ ಜಲದಿಯ ನಿಜಿಗಿದ ಹನುಮನುದಿಸಿದ ನಾಡು. ಓ ಜಯಿಂ ಮೆರೆದರ ಸುಗಳ ಸಾಹಸದ ಸೂಡು, ಓ ಜಯಿಂ ಮೆರೆದರ ಸುಗಳ ಸಾಹಸದ ಸೂಡು. ತೇಜವನು ನಮಗೀವ ವೀರ ವೃಂದದ ನಾಡು. ಉದಯವಾಗಲಿ ನಮ್ಮ ಚೆಲುವ ಕನ್ನಡ ನಾಡು, ಬದುಕು ಬಳುಹಿನ ನಿಧಿಯು ಸದಭಿಮಾನದ ಗೂಡು. ಉದಯವಾಗಲಿ ನಮ್ಮ ಚೆಲುವ ಕನ್ನಡ ನಾಡು.
I request our chief guest, Mr. Vikram Hoylagola, to address the gathering.
Honorable dignitaries on the dais, judicial officers off the dais, learned senior advocates, learned advocates, law officers, family members, and my dear friends. At the outset, I owe all of you an apology for what you are going to have to endure over the next half an hour to 45 minutes. In this beautiful setting, if you expect me not to be distracted and give a speech without having to look over or with a beautiful sunset in the background, I think you expect too much of me. ನನ್ನ ಕೈಯಲ್ಲಂತೂ ಆಗಲ್ಲ. ಇಲ್ಲಿ ಅಲ್ಲಿ ನೋಡ್ತಾ ಇರ್ತೀನಿ. ಅದಕ್ಕೆ ಈಗಲೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಐ ಆಮ್ ವೆರಿ ಸಾರಿ ಇನ್ ಅಡ್ವಾನ್ಸ್. ನಾನೇನೋ ಮನ್ಸು ಮಾಡಿ ಬಂದಿದ್ದೆ ಇಷ್ಟೆಲ್ಲ ಮಾತಾಡೋಕ್ಕೆ, ಬಟ್ ಈ ಕಡೆಗೆ ನೋಡ್ತಾ ಇರ್ತೀನಿ. ಸೊ ಪ್ಲೀಸ್ ಐ ಓ ಯು ಆಲ್ ಅನ್ ಅಪಾಲಜಿ ಇನ್ ಅಡ್ವಾನ್ಸ್. ಎರಡನೇದು, ವಿತ್ ಆಲ್ ದಿಸ್ ಬ್ಯೂಟಿಫುಲ್ ಸೆಲಿಬ್ರೇಷನ್, ನಾಳೆ ನಮ್ಮ ಬೇಸಿಗೆ ರಜೆಗಳು ಶುರು ಆಗ್ತಾಯಿದೆ. ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಲಿಸನ್ ಟು ಮೀ ಟಾಕಿಂಗ್ ಅಬೌಟ್ what I plan to talk about, that also I owe an apology, because I'm the only one standing in between all of you and a very hearty dinner, I'm sure, which is awaiting all of us. So please, at the outset, I apologize. Please bear with me. I will try and make it as interesting and fruitful as possible. Before I start with the subject, on a more serious note, Justice Krishna Dikshit Sahib ಇಲ್ಲಿ ಬಂದಿದ್ದರು. ಅವ್ರ ಸ್ಪೀಚ್ನ ನೋಡ್ತಾ ಇದ್ದೆ. ಆ್ಯಂಡ್ ಒನ್ ಥಿಂಗ್ ದಟ್ ಸ್ಟ್ರಕ್ ಮಿ, ಆ್ಯಂಡ್ ಇನ್ಫ್ಯಾಕ್ಟ್ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ನನಗೆ ಫೋನ್ ಮಾಡಿದಾಗ, 3 ವಾರದ್ದು 4 ವಾರದ ಹಿಂದೆ ಫೋನ್ ಮಾಡಿದಾಗ, ದ ಫಸ್ಟ್ ಥಿಂಗ್ ದಟ್ ಅಕರ್ಡ್ ಟು ಮೀ ವಾಸ್ ಅ ಸೆನ್ಸ್ ಆಫ್ ಓವರ್ವೆಲ್ಮಿಂಗ್ ಆ. ಯಾಕೆ ಅಂದರೆ, ವೆನ್ ಒನ್ ಥಿಂಕ್ಸ್ ಆಫ್ ದ Mangalore Bar Association and the contribution of the Mangalore Bar to the judicial and legal history of Karnataka, I don't think anybody in the state can say I am wrong if I say that there is no other district in the state of Karnataka that has contributed more to the development of law in the entire state. Nobody can prove me wrong. I don't need to say any names. In fact, why I remember Justice Krishna Dikshit was, he said there must be something about the flora, and in his words, as eloquent as he always is, he said there must be something about the flora and fauna in this district. So many great lawyers, so many great judges have come from these areas. So when the Honorable President first called me, I said, I hope I will be able to do justice, because it is a sense of awe when I stand in front of you. I see future senior advocates, future judges, because this district has nothing to contribute but greatness. So with that, I will start off with what I intend to speak on. In fact, I must be, in all honesty, when I was asked to speak over here, I was a little unsure about what to speak. My experience over the years has taken me through various subjects. Some people ask me to talk about tax laws, some people ask me to talk about various, but I thought something which is relevant in this day and age, without commenting on any of the actual incidents. What I did was I checked about 3-4 months of, I googled what's been happening in the legal circles, in the judiciary over the last 3-4 months. And one recurring theme, one thing I constantly saw being repeated in the news articles, is this so-called confrontation between the government, that is the executive, and the judiciary. Of course, I will not go into the real issue. The real issue seems to be regarding the appointment of judges. Frankly, I do not have the expertise nor the authority to comment about that. So I will not go into that subject. But what I thought of was, let us see is this something new that has happened? Is this peculiar to 2022-23, or is this something that has been happening over many years, and how did it all start? And if I have to say, the single point of this so-called, I don't like using the word confrontation, but the so-called friction is the power that the judiciary has been vested with by the Constitution for judicially reviewing legislative and administrative action. And interestingly, when I was going through the research, it's something which was never contemplated. See, democracy started off flourishing in the Western world, in the United Kingdom, in America, and the original concept of democracy was that there is a legislature to make all the laws. They will legislate. There will be an executive who will implement these laws. And the judiciary's role was really to interpret those laws, and that's all. If there is any dispute between two property owners, the judiciary has to resolve that dispute. If there is a dispute regarding interpretation of the Constitution, the judiciary has to merely interpret the Constitution or interpret the laws. But then, interestingly, my research brought up one judgment of the United States, and this was a very, very interesting fact. So I'll take about 2 minutes to narrate the facts of that case. We have to go back 220 years to 1803. The United States Constitution, I'm not sure, they got their freedom sometime in 1776, but I'm not sure exactly. Sometime in between 1776 and 1800, the US Constitution was brought into force. Then what happened was, in the year 1800, there was a president called John Adams. He had been voted out of power. And some of you might have heard, the great Thomas Jefferson was to become the next president. Now, interestingly, this is, we think that this is something that is new and that the old generations never did some things like this. But you'll be interested to know that at 12 o'clock, I think in 1801, April 1st or March 1st, President Adams had to demit office. At the nth hour, he wanted to ensure that the judiciary is filled with judges who are favorable to his party. I think it was called the Federalist Party. Now we have different parties in the United States, but he wanted to fill, so it's not something that is new. Even then, so at the nth hour, he issued what are called commissions for appointment of various judges. But it had to reach the judges by midnight, because at midnight, Thomas Jefferson took over and said, I will recall all those commissions. So the judgment is in the name of Marbury versus Madison. There was one Mr. Marbury who was supposed to be appointed as a judge, but by 12 o'clock, his commission had not reached him. Thomas Jefferson immediately told his whoever secretary or whoever was supposed to deliver the commission, he said, no, now I am the president. At 12 o'clock, I have taken over. Do not deliver the commission to Mr. Marbury. Mr. Marbury went to the United States Supreme Court and said, issue a writ of mandamus to the executive to hand me over my commission so that I can take over as a judge of whichever court he was supposed to be appointed as. Before this Supreme Court, interestingly, unlike our Supreme Court and unlike our high courts, the Constitution does not vest the power of issuing a mandamus to any authority. So the United States Supreme Court does not have the power to issue a mandamus, or at least did not at that point in time. There was something called the Judiciary Act of 1789, which vested the power in the Supreme Court to issue a writ of mandamus. The argument the government took up before the Supreme Court was that the Act of 1789 itself is ultra vires the Constitution, because the Constitution does not vest the power in the Supreme Court to issue a writ of mandamus. Now, please remember at that time, there were three pillars of government, as I said, legislature, executive, judiciary. Judiciary, all it had to do was interpret the law. For the first time, the Supreme Court was faced with the question, what happens if there is a law which is contrary to the Constitution? Finally, in 1803, the United States Supreme Court, for the first time, exercised what we now is known as the power of judicial review of legislative action. And it struck down that particular provision of the Judiciary Act of 1789 and said, no, we do not have the power to issue a writ of mandamus, because that act which confers power on us to, that is the Supreme Court, to issue a writ of mandamus is ultra vires the Constitution itself. So they refused to issue that mandamus on the ground that the act is ultra vires. So that is the first case in legal history where the judiciary struck down something, a legislation passed by the legislature. Then the law on that front, judicial review, United States Supreme Court went ahead. UK, interestingly, never really developed on that front. They still, even to date, to a large extent maintain those watertight compartments. But in India, there was one case in Emperor versus Burra, I think in the year 1877, where, again, if you go back, we didn't have a Supreme Court then. There were the judicature courts of Calcutta, Madras, and Bombay. Calcutta High Court said, yes, we have the power. Again, tracing it back to Marbury versus Madison, the Calcutta High Court for the first time in 1877 said, yes, we have the power of judicial review. I will not go into the facts because it may not be that relevant. But for the first time on Indian shores, albeit on British Indian shores, the power of judicial review was exercised. Now, really, this is the history that really interested me. What happened in the meantime was, in the US, the power of judicial review was being expanded. The confrontation between the executive there, or the legislature there in US, and the judiciary became more frequent. And that was a time, please remember, that was a time when social legislations were being enacted across the world. Of course, in Russia, there was a move towards communism and then towards socialism. US went the other way, but still, there were some states which were slightly what these days the media calls left-leaning. And they started enacting laws, those states are enacting laws to protect the social interests of the citizens. So, for example, the state of New York enacted a law which restricted the number of working hours that a person can do in a day. Because at that time, exploitation was rife. There was nothing that, there was no minimum wages. A person could be made to work 22 hours a day with no guarantee that he will be compensated for extra time or anything of overtime or anything like that. So finally, there was a law that was enacted by the New York state. It was a state law. United States Supreme Court struck it down. Again, exercising power of judicial review, saying there is a freedom of contract that is vested in every citizen under the Constitution. Just like what we have in our Constitution, say right to life and so on, they traced it back to one of the articles in their Constitution and said that this law is violated. So if somebody wants to work 20 hours a day, who are you to tell him not to work 20 hours a day? Interestingly, a few years after that, this was in the case of Lochner versus State of New York. Just a few years after that, a similar law passed by another state in the United States, which restricted the number of hours women could work. The first was across both men and women. The second law was only women. There, the United States Supreme Court, for reasons best known to them, said this law is perfectly fine because women need to be protected and so on. So why I'm saying all this is, there was a problem that was arising, which people began to see, that the essence of a democracy is that the will of the people is spoken through the legislature. We want a particular government to be voted into power. They will enact laws on our behalf because they are speaking on our behalf. Who is the judiciary to start saying, no, those laws are unconstitutional, those laws are unenforceable? Then that was an issue that was being realized even in India. So when the Constituent Assembly started meeting in late 1946, all of these were considered by the great constitution framers we had. And particularly Nehru himself, because as we all know, he himself was quite socialist minded. He was quite influenced by the socialist revolution. And he was particularly worried where, please remember that we are in late 1940s, we are in a post-World War zone, we are in a post-India, post-British India, where we have been ruled by a foreign power for almost 200 years. So Nehru and some other constitution framers were very worried where we will now start passing social reform legislation like in the United States. And if we confer power of judicial review on the Supreme Court or on the High Courts, our laws will be tested and possibly we will not be able to enforce what we want to do. So, in fact, a very interesting quote from Nehru. This was in 1949. So, this is 10th September 1949. Please remember, this constitution was adopted, as you all celebrated Law Day, on 26th November 1949. So, little more than 2 months before, what Nehru said, I will just quote. He said, within limits, no judge and no Supreme Court can make itself a third chamber. No Supreme Court and no judiciary can stand in judgment over the sovereign will of Parliament, representing the will of the entire community. If we go wrong here and there, it can point it out. But in the ultimate analysis, where the future of the community is concerned, no judiciary can come in the way. It is desirable to have people whose duty is not in any small matters, but with regard to basic principles that you lay down, to see that you do not go wrong, as sometimes even the legislature may go wrong. But ultimately, the fact remains that the legislature must be supreme and must not be interfered with by the courts of law in such measures of social reform. That's why I started. When I first started off, I said, is this what we are seeing in 2023 or 22? Is it new? Not at all. When our constitution was framed itself, there was a concern that there will be certain confrontations between the judiciary and the legislature and or the executive. So it's nothing new. This has been going on right from the inception of our country itself. In fact, not just Nehru. In fact, Mr. Shri Alladi Krishnaswamy Iyer also said this. He said, while there can be no two opinions on the need for the maintenance of judicial independence, both for safeguarding individual liberty and proper working of the Constitution, it is also necessary to keep in view one important principle. The doctrine of independence is not to be raised to the level of a dogma so as to enable the judiciary to function as a kind of a super legislature or a super executive. The judiciary is there to interpret the Constitution or adjudicate upon the rights between the parties concerned. It's not very different. If you read the articles upon some comments recently made by some of the union ministers, including the law minister, it doesn't seem very different. The same problem seems to be happening. Same problem, or at least is perceived to be happening. But despite all of this objection, there finally in our constitution, the power of judicial review was recognized within. And that is there under Article 13 itself, when Article 32 and Article 226 clearly, expressly gave the power to the Supreme Court and the High Courts to issue writs. Article 13 was equally important. Article 13 said that no law which is in violation of this part, that is the fundamental rights, that no law can be made in contravention of the fundamental rights enshrined under Part 3 of the Constitution. So therefore, the power of judicial review finally came to be constitutionally recognized itself. Unlike, say, as I was saying in the US Constitution, where the Constitution does not speak of judicial review. It is a judge-made concept. Here in India, we have a constitutionally recognized concept of judicial review itself. But still, that fear was there, that yes, we are going to introduce various social reforms and the judiciary might nip it in the bud or come in the way of us implementing these social reforms. And to give credit, Mr. Nehru and Mr. Alladi Krishnaswamy Iyer were not very wrong. It did not take very long at all. There were two instances in the very first year of our republic itself, after the constitution was enforced. In 1951, one, the great case of State of Madras versus Champakam Dorairajan. There, a reservation, a government order that gave a caste-based reservation was struck down by the Madras High Court and affirmed by the Supreme Court, saying that there is no power to reserve based on caste. So already one social reform where reservation was sought to be introduced on the basis of historically wronged castes was struck down by the Supreme Court. Second, land reforms, as you all know, was an important social reform measure which was sought to be introduced in light of various injustices that were committed during the British India period and before. So land reforms was very close to Nehru's heart. The Patna High Court struck down the Bihar Land Reforms Act. That was also in the year 1951 itself. Then that is when the parliament swung into action and said, see, this is what we have been fearing. This is what has happened. What social reforms we want to do, this Supreme Court and the High Courts are coming in the way. Therefore, 1951 itself, the first Constitution Amendment Act was brought into force. Interesting, very, very interesting. Now, I won't take you all through the entire provisions, but two very important articles. Article 15.4 was inserted to make sure that there can be reservation on the basis of caste. But other than that, there were two other important amendments. Articles 31A and 31B were introduced into the Constitution. Article 31A protected certain legislations regarding acquisition by the state, taking over of management of property, amalgamation of two or more corporations. What the parliament said was, we will amend the Constitution to ensure that any law relating to this cannot be a subject matter of judicial review. Then Article 31B also. Article 31B introduced a ninth schedule into the Constitution and said whatever laws we place under that ninth schedule, no question of judicial review. Immediately, the First Amendment Act was, of course, challenged. And I'm sure all of you have the famous first Shankari Prasad's case, where the Honorable Supreme Court upheld the first Constitution Amendment. Allow me to digress for a bit here, but again, the argument taken there was that the Article 13, Clause 2 says, no law shall be made in contravention of the fundamental rights. The law to amend and insert Article 31A and B was in exercise of the powers under Article 368, and that law, which had to be passed in Parliament, is violative of Article 13.2, is violative of the fundamental rights, and therefore falls foul of Article 13.2. That was the argument taken. The Supreme Court said no. Supreme Court said there are two distinct powers the Parliament has. One is the legislative power, under which the plenary power is exercised and ordinary legislations are enacted. Second is the constituent power under Article 368, and the constituent power is never contemplated under Article 13.2. So that was the famous Shankari Prasad's case, which came to be affirmed in about 12, 13 years later in Sajjan Singh's case. And then as a marked shift from the earlier position, Supreme Court in Golaknath's case said that no, any law means even a law passed under Article 368 will have to satisfy the test of Article 13.2. And therefore, no fundamental right, no law can be made that will abridge any fundamental right. So, in 1967, the Supreme Court took a full 180-degree shift and went the other way and said no law can be made. So, why I'm highlighting all of this is, of course, that ended with in the famous Keshavanand Bharati case. I'll come to that. But why I'm highlighting all of this is to show that this friction between the legislature and executive and the judiciary is a constant recurring theme in the history of independent India. It is not something new at all. There has constantly been this so-called confrontation or friction. And of course, all of this came to an ugly sort of head in 1973 and 74, with the judgment being passed in Keshavanand Bharati's case, where they modified the law in Golaknath, and as you all know, as students of constitutional law, all of you would be aware, the basic structure doctrine was for the first time was introduced, where they said, yes, the power of amending fundamental rights will be there. Power of amending any other constitutional provision is there. But you cannot tinker or you cannot take away anything that will affect the basic structure of the Constitution. And of course, in that basic structure doctrine has been evolved over a period of time, but it goes without saying that separation of powers, judicial independence, and so on are a part of the basic structure, and therefore, including the power of judicial review. So, in Keshavanand Bharati's case, for the first time, this concept of basic structure was introduced. Here again, I think this is one of the most difficult phases in independent India's history, where after Keshavanand Bharati's case, the confrontation, and there I don't think there can be any two ways that there was a confrontation between the executive and the judiciary, where three judges, including one great son of this district, Justice K.S. Hegde, was superseded. And Justice A.N. Ray, who had passed one of the minority judgments in Keshwanand Bharati, was made the Chief Justice. So therefore, this confrontation came to a very ugly head. In fact, even with the Raj Narayan's case going all the way to the Supreme Court and the Parliament enacting a law which said no, enacting a law which amended the Constitution to say that no the election of a prime minister or so on cannot be questioned in any court of law. That thankfully was struck down by the Supreme Court, said that that is in violation of the power of judicial review, which is enshrined in the Constitution as a part of the basic structure. So that confrontation came to a very nasty head, of course, which culminated in an even nastier circumstance with the introduction of emergency. And of course, at that time, the Honorable Supreme Court, as a number of authors have said, had passed one of its most notorious judgments in ADM Jabalpur with the great dissent of Justice Khanna. But things began to improve after that. I think with the experiences, with the lessons everyone learnt from the dark era of the emergency, then the Minerval Mills judgment came as a breath of fresh air, where the Supreme Court finally once again put its foot down and said, yes, we will exercise our power of judicial review. The legislature cannot dictate terms to us. The legislature cannot pass laws that amend the Constitution to derogate or abrogate fundamental rights. So by the early 80s, gradually that confrontation came to be less. It still, of course, was there. It was not as if it disappeared altogether, but it was not as bad as the dark days of the emergency and just before that. So finally, what happened, of course, I will come to the 1980s and how the law developed afterwards. But I'll just, before that, touch upon, since I'm anyway discussing the power of judicial review, one, of course, as I said, is the power to strike down a law if it is in violation of the Constitution. But there is also another power, there is also another ground on which a legislature can be struck down. That's not traceable to Article 13, Clause 2, but to Article 245 and 246, where the competence to pass laws, read with the 7th schedule to the Constitution, have been given to either the union or the states, either the parliament or the states. So therefore, for the sake of completeness, I should also mention that the only ground of judicial review is not on the ground that it abrogates fundamental rights or it's violative of any other constitutional provision, but also that either the parliament or the states do not have the legislative competence to pass such a law. So therefore, number of laws have been struck down on the ground that the union is encroaching upon the power reserved for the states, or vice versa. The state has passed a law which is encroaching upon the power reserved for the union. But in the 80s, as I was saying, there was also a broadening of the scope of judicial review of administrative action as well. So on one hand, there was a bit of the confrontation regarding the legislature and the laws they passed. On the other hand, the Supreme Court gradually started expanding their powers of judicial review of administrative action as well. So therefore, over a period of time, number of principles have been evolved by the Supreme Court, where the correctness or the legality or the propriety of administrative action can also be tested before the writ courts, either the High Court or the Supreme Court. I will not spend too much time on it, but it's sufficient to state that there are some important principles on which judicial review of administrative action can be done. One is that if the court finds that there is a procedural impropriety in the administrative action that is taken, so therefore if a hearing has not been given, or if the procedure prescribed in law has not been strictly followed, that is the law to strike down that administrative action. To irrationality. Now, irrationality is something which is again borrowed from the UK judgments, where it's called the Wednesbury principle, where the administrative decision is so completely devoid of any rationality, that no person could possibly have come to such a conclusion, then the administrative action, even though it may be procedurally right, can be struck down on the ground of irrationality. Then, of course, there is natural justice like bias and so on. That, interestingly, is also the question of proportionality. Is that administrative decision proportional to meet the ends for which that decision has been taken? Classic example I will give you. Recently, when I was serving as a government advocate in the High Court, I was asked to assist the Advocate General on the validity of a Section 144 CRPC order that was issued in the wake of all those CAA protests. This was in 2019 December, if I remember right. And one of the grounds which was raised in that petition was that a 144 order was grossly disproportionate to what is actually happening on the ground. Of course, at that time, the Supreme Court was also hearing the action taken to ban all internet services in Jammu and Kashmir. And the judgment, while the case before the High Court was pending, the judgment of Anuradha Bhasin came out in Delhi in the Supreme Court, where the Supreme Court consolidated the laws and included, that is also commented on the ground of proportionality. So therefore, if a Section 144 order or any other administrative order is found to be grossly disproportionate to the ends that is sought to be achieved by it, it can be struck down. And of course, the last ground is if the administrative act itself is ultra vires the parent act, if there is no jurisdiction cast on that authority, or if it is the authority that is exercised is contrary to the parent act, it can be struck down by the writ court. So therefore, you have judicial review of legislative action and judicial review of administrative action. Why I said this was, by the time the 1980s came, this judicial review of administrative action was slowly expanding in scope. And there arises a problem. Why I said I'll come back to irrationality. Irrationality by its very nature is a very subjective. I may think something is extremely irrational. Another person may think that is fairly reasonable, not so irrational. So the difficult part that arose there is, when you are judging administrative action, the courts sometimes started treading upon the policy decisions that are left for the executive. So therefore, a policy decision to disinvest a particular company, it came up in the case of Balco. Union government back in the early 2000s took a decision to disinvest its shareholding in Balco. That was challenged in the Supreme Court. And Supreme Court said very clearly, it is not within the domain of the courts to embark upon an inquiry as to whether a particular policy is wise or a better public policy can be evolved. So therefore, the courts also needed to pull themselves back and say, listen, we are not going to go into policy decisions because we still need to respect the power that has been constitutionally placed in the hands of the executive. So therefore, if they take a policy decision, we need to respect that and draw our boundaries. Recently, in fact, I think maybe in 2019 or 20 again, the decision of the union government to buy those Rafale jets was questioned. There again, the Supreme Court said, listen, we are not going into policy decisions. Whether you want to buy Rafale jets or you want to buy some Russian jets or you want to buy some F-16 or F-18 jets from America, we don't know. The executive has been vested with the power because they have the expertise to take those decisions. Now, 4 or 5 Supreme Court judges, frankly, do not have the expertise to know which jet is better than the other jet. I may, as an enthusiast or a student of aircrafts, place thousands of documents before the Supreme Court to say, no, see, I can prove that Rafale is not a good purchase, or that Rafale, the same jets could have been bought at a lower rate from Russia. But the Supreme Court said, no, we are not going to go into policy decisions. So they had to pull themselves back. And I'll come to why this, and I'll also come to the point that the Supreme Court also, in all humility, I have to submit that there is a thin line where the Supreme Court also may have crossed that line, or the High Courts also may have crossed that line sometimes. So this is where we were in the early 80s. Then came, in my opinion, a wonderful concept, but an equally abused concept, that is the public interest litigation. And that started being evolved in the early 80s with Chief Justice Chandrachud and Chief Justice Bhagwati. It started off with that Hussain Ara Khatun case, where under trial prisoners, of course, Hussain Ara Khatun herself was, it was not a public interest litigation because she was privately interested in that. But there the Supreme Court, based upon the petition of one person, took on the cause of thousands of other under trial prisoners. So the concept of public interest litigation began then. Then it moved on to S.P. Gupta's case regarding transfer of judges. There was the Bandhua Mukti Morcha case, again, where the Supreme Court, based on a simple letter. So Bandhua Mukti Morcha was a case where I think several employees had been deprived of even minimum wages and made to work in the most horrendous conditions. And the Supreme Court came to their aid. So why I started off saying that it's a wonderful concept because originally it really was a breath of fresh air. The Supreme Court actually devised this concept of PIL to ensure that those communities, those persons who do not have, say, the financial power or the resources to file petitions and get and knock on the doors of the court, we will stand up for them. Even if one person, he need not have locus standi, any socially interested or publicly interested activist can file a petition. We will take on the cause of all those who are unjustly treated. And there, with the concept of PIL developing, the scope of judicial review automatically started expanding, because in every judgment now, what the Supreme Court started doing was expanding the scope of Article 21. Article 21, as we know, if you read A.K. Gopalan's case, you will not be able to believe how from A.K. Gopalan we have come to what Article 21 is now considered. A.K. Gopalan took a very narrow view of Article 21. Now Article 21 includes right to speedy trial, right to free legal aid, right to dignity, livelihood, education. These are just some small list I made. The list goes on and on. Medical care, environment, solitary confinement, bondage, so on. So environment, for example, you've seen the whole line of MC Mehta judgments. There is no denying that the Supreme Court did a number of good things for the betterment of the country or for that particular state. But there, again, there's that thin line. If you ask me to argue a point saying that the Supreme Court may have crossed the line, I may be able to make a very decent case in all of these cases where the Supreme Court and the High Court started expanding that scope of PIL. Possibly the traditional concept, you see where we started off from. Nehru and Krishnaswamy Iyer and all were worried about judicial review of their legislative action. Now every decision, almost every decision of the state and the union could be questioned in a court of law, and the court started taking upon themselves the power to question the wisdom of those decisions. Of course, that again, whether to question policy decision or not is a very, very thin line again. What I may consider as a policy decision, somebody else may say it's not a policy decision. It affects their fundamental right under Article 21. Therefore, I have the power to take on the case and pass necessary orders. So therefore, the courts also, with great respect, started possibly crossing that line, that thin line. Again, very subjective matter. It's not, so what I'm trying to say is it's not a one-man blame game where only the executive or the legislative is at fault. The judiciary also started possibly exceeding what the powers were originally thought were conferred on them. But I will still say that in the majority of the cases, the Supreme Court or the High Courts were right in doing so, because eventually it was to correct a particular injustice that they thought was being done by the executive. So possibly you can justify it because the ends justify the means. Then again, as I said, with Article 21 being developed, the Supreme Court also developed the theory of compensation itself. They said, okay, we will not only decide whether fundamental rights have been violated, but we, as a writ court, have an inherent power to even award compensation. Now that was again a marked departure. There are problems again though. There are problems because how do you quantify that compensation? In one case, let us say there is some accident that is on account of the fact that roads are not being properly maintained. The state someone falls in a pothole and unfortunately passes away. Now, how do you determine that? Under Motor Vehicles Act and so on, you have principles to determine compensation. But the writ courts, it becomes subjective. One court may think 1 lakh is sufficient. One court may think 1 crore is sufficient. So therefore, there are no principles. There again, there is a gray area where once you start awarding compensation as well, one is just punitive. But when you start saying we want to compensate for loss of life, loss of under all those motor vehicle principles, there again it becomes a little subjective because they're strictly speaking, the writ courts are not bound by those laws. So there again, the High Court started and the Supreme Court started evolving its own jurisprudence on that count. Now, why I'm saying all this is, I started off saying that the PIL concept was wonderfully thought of, but is heavily subject to misuse as well. And I myself, without citing any examples, I myself have been privy, as a government advocate, have been privy to various absolutely frivolous PILs that are filed, either for personal publicity or possibly it is politically interested, or I am personally affected by my neighboring property owner. I cannot file any petition against him. I will send 5 other people saying, "Nee one public interest litigation act badi court to hota hai." So all that, now those are cases I have seen where it is being done. And that is where courts have to be very, very, very vigilant to ensure that their powers are not misused and that the PIL concept is used for what was originally thought of. That is to stand up for the rights of the voiceless, the marginalized, the oppressed communities and so on. But with this expanding scope of PIL and particularly with this expanding scope of Article 21, the PIL concept, I think I can safely say that sometimes even 50% of PILs are in some way or the other personally motivated or politically motivated, especially politically motivated. I have seen for myself where there will be possibly some persons who are politically interested, but they don't have the resources to become a lawmaker or join the government. They will use the PIL to promote their political agenda or their political manifestos. Now, there again, the courts have to be very, very vigilant to ensure that they are not misused. Because eventually the judiciary has to stand for itself. The judiciary has to ensure that they are not used as a tool by political parties to make some statements. So therefore, the judiciary has to be very, very vigilant with such PILs. One example, recently, that Central Vista project, which was devised by the central government, that was challenged. Supreme Court laid down several guidelines about how PIL, these sort of issues should not be considered a PIL. Whether to build a building which is 5 floors high, whether it is should be 10 floors high, or whether it should only be a ground floor. We are not concerned with that. You may want to make somebody may want to make a political statement saying why Central Vista is not required. It is not doing anything to enhance Delhi's beauty. But that Supreme Court rightly said we are not going to interfere in that. On a lighter note, I pulled out some PILs which I had seen which were filed, which of course thankfully were all dismissed. Somebody wanted, just like the Great Wall of China, they wanted a Great Wall of India to be built across the entire border of India, across from Pakistan to China. Supreme Court said, sorry, we are not getting into all that. We are not directing the government to build any walls. Then in that Nirbhaya case, the unfortunate incident that happened in Delhi, somebody filed a PIL saying that before executing those convicts, that they should be given the option of organ donation. Supreme Court said, listen, we are not getting into all those questions. If they want to give their organs, so be it, but we can't getting into all that. Then there was a PIL that said India should be renamed as Bharat. I mean, these are classic examples of how PILs are completely misused. Last 2 things before I conclude. One, I owe it as somebody who was fortunate to have been a part of the entire process, to show how the exact opposite, how PILs can be effectively used. When lockdown was announced, 24th or 25th March, 3 years ago, a lot of us, including myself, I remember I was sitting at home not knowing what to do. I think I was reading some book and I told my wife, I don't know how I'm going to do this for 3 weeks. I'll get very bored. I think I spoke too soon. Literally about 10 minutes later, the Advocate General called me and said, Vikram, Chief Justice hearing ಕರೆದಿದ್ದಾರೆ ನಾಳೆದ್ದು ನೀನು ಹೋಗು ಧ್ಯಾನ್ ಚಿನ್ನಪ್ಪ was the additional AG ನೀನು ಧ್ಯಾನ್ ಹೋಗು. I said, very well, sir. And at that time, I thought, a whole nation is under a lockdown. What issues could there possibly be? And I was so wrong. And I even though half of my gray hair is because of those few months handling this so-called COVID PIL, the end result will gives me so much satisfaction that I'm fairly sure I'm very sure that nothing I have done so far, and fairly sure that nothing I will do henceforth also will give me that much satisfaction. Now, I'll tell you how the court conducted that PIL. On the first day when I went, the then Honorable Chief Justice, along with Justice Nagaratna, said, we have made about 13 or 14 issues. My head was spinning there. I said, what 13? I couldn't even think of one issue. And then the court started saying, you make a note of all this. We want a reply in the next 3 days. And please remember, this is in the midst of lockdown where it's difficult to even get to the court. And he's made a list. How are midday meal scheme being implemented? How is Anganwadi scheme being implemented? How are migrant workers being fed? What is the food distribution scheme for the homeless? And a whole list of... and that's when I started asking myself, okay, correct. What exactly is happening with all... See, as we are fortunate to be privileged to have a roof over our heads and I'm sure all of us had fairly sufficient income at that point at that time it was supposed to be 3 weeks. No one knew that it's going to be extended further. So those were issues that did not immediately occur to our mind. But to give credit to the court, Chief Justice Oak and Justice Nagaratna came up with all these issues. And they said, give us a reply. And amazingly, I dealt with that PIL for more than a year. First as the government advocate, and then I was appointed as amicus curiae in that. I cannot, except for the end, I'll come to that. Except till the end, the court handled that PIL in such a remarkable manner that there was not a single mandamus issued to the state. It was through this process of constantly questioning. Yes, Vikram, you tell me, how are you, what are you doing for, if you remember when lockdown was lifted, how are migrant workers going back to their states? How are you ensuring that? And we would give answers. I would speak to the concerned government officials, I would give answers. And the court would constantly say, why are you doing this? Should this not be a better way of doing it? But the court would never give a direction because the court knew that those are essentially policy matters. But through this inquisitorial process, we also realize that sometimes the decisions that the government is taking may not be correct. Maybe there's a better way of doing it. So then we would go back, both Mr. Dhyan and I would go back, speak to the concerned IAS officers and tell them, Nodi, hige madidre, maybe we can have a better result. Okay, we'll do that. So through this process, you will not believe the number of thousands of workers that ended up getting a better meal on their plates, or at least a meal on their plates. Thousands of workers who could go home immediately after lockdown was announced because we constantly were, when I say we, the government was constantly improving the transportation system. We were sending more trains, we were sending buses. In fact, there was one time when the government was charging people to go back. And all the High Court said was, come here, why are you charging? So, and immediately after that, because we knew it would be difficult to justify having kept them at home for 6 weeks and not having paid them any money, how are we charging them? The government itself took a decision. So just see how the PIL was used. Thousands, lakhs of people were benefited from that one PIL. So if the PIL is correctly used, it can be a great source of betterment of this country. When one last, I think finally, I think in May or June, some of you would have seen, finally I think the court got fed up when this is one incident in Chamarajnagar, where I think 30 odd people unfortunately died because of oxygen shortage. Finally, the court, I think, gave a mandamus to the state to procure I forget how many metric tons of oxygen. That was challenged in the Supreme Court and upheld by the Supreme Court because it was a reasoned order. But other than that, simply by asking questions to the government and suggesting, not directing, suggesting better ways to do it, the state was benefited, the country was benefited. So the PIL concept can be used for many, many good purposes. So having shared my experience with that, I think I will conclude. Like I said, I'm probably eating into, sorry for the use of word, but eating into your dinner time. But having traced the history, I'll conclude by saying this. Judiciary has been given the solemn duty of keeping a check on the possible excessive powers of the judiciary and of the executive and the legislature. As I said, the concept of a judicial review has been constitutionally enshrined, unlike in the other countries. So therefore, the judiciary must always ensure that no executive excesses, no legislative excesses will be tolerated. But at the same time, as I said, there are instances where the executive may have a point that the judiciary may be crossing a line. Without giving any examples, I'm sure all of you can think of examples where the judiciary may have crossed that line. So the judiciary again has to be careful that that line is not crossed, and the original concept of judicial review is upheld. So therefore, I'll conclude by saying this. When I said initially the law minister made a statement that there's this constant confrontation between the executive and judiciary, it's nothing new. It is not this government. There have been several governments that have had confrontations with the judiciary. But at the same time, can I say that the law minister is fully wrong? No, he's not fully wrong. But if the judiciary is expected to stay completely away and say, I will not stand up for the rights of the citizens even when I find that the executive is exceeding its powers, then I think possibly it is wrong. So with those words, I thank you all for giving me this opportunity. As I said, it's overwhelming to have to come to Mangalore and speak to such distinguished members of the bar and with judicial officers also present. So with those kind words, I thank you. Jai Hind, Jai Karnataka. Thank you.
When I transfer my knowledge, I teach. When I transfer my belief, I doctrine. Let's thank one such person, Mr. B.B. Chakati Sir, Additional District and Session Judge, Karnataka, Dakshin Kannada, who has served in Mangalore from 1/6/2020, who has now been transferred. We take this honor to show our gratitude to you, sir. Additional Senior Civil Judge, Mangalore, Dakshin Kannada, Srimati Shilpa A.G. to receive a token of gratitude from Mangalore Bar Association for serving in Mangalore from 8/7/2021 and now being transferred.
Today it is an emotional moment because I'm being given a send-off. At the same time, I'm very happy because the Honorable High Court of Karnataka has considered my place of choice, Mysore, because I come from Coorg district. I extend an open invitation to you all whenever you come to Mysore. Please be kind enough to come and meet me. I'll be very happy. I really appreciate the standard of practice, hard work and the dedication put by the bar members of the Mangalore Association. And my court has always been a very lively court, and you were all kind enough, showed me utmost respect and concern. I'm thankful to all of you. ನನಗೆ ಯಾವುದೇ ರಿಗ್ರೆಟ್ಸ್ ಇಲ್ಲ. ಐ ಹ್ಯಾವ್ ಎಂಜಾಯ್ಡ್ ಮೈ ಟೈಮ್ ಇನ್ ಮ್ಯಾಂಗ್ಳೂರ್. ಎಲ್ಲ ಇವೆಂಟಿಗೂ ನಮ್ಮನ್ನು ಕರೀತಿದ್ರಿ, ಆದರೆ ಒಂದು ಇವೆಂಟಿಗೆ ನಮ್ಮನ್ನು ಕರೀಲಿಲ್ಲ. ಯಾವುದು ಅಂದರೆ ಅದು ಕುಕಿಂಗ್ ವಿತೌಟ್ ಫೈರ್. ಇಟ್ ಈಸ್ ವೆರಿ ಹೆಲ್ಪ್ಫುಲ್ ಟು ವಿಮೆನ್ ಲೇಡಿ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ಸ್. ಅದನ್ನು ನಮಗೆ ಸ್ವಲ್ಪ ಹೇಳ್ಕೊಟ್ಬಿಟ್ಟಿದ್ದರೆ, ಟೈಮ್ ಕನ್ಸ್ಟ್ರೈನ್ಸ್ ಇರೋದ್ರಿಂದ ಇಟ್ ವಾಸ್ ಅ ವಂಡರ್ಫುಲ್ ಈವೆಂಟ್ ಫಾರ್ ಅಸ್. ಎನಿಹೌ, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಫಾರ್ ಯುವರ್ ಕನ್ಸರ್ನ್ ಆ್ಯಂಡ್ ಅಫೆಕ್ಷನ್. ಹ್ಯಾವ್ ಅ ಗ್ರೇಟ್ ಲೈಫ್. ನಮಸ್ತೆ.
It's an immense pleasure to say that even the advocates of Mangalore Bar Association have taken the further steps towards their career, and now let's felicitate them. I request the defense counsels who have been appointed, Mr. Shuk Raj, Mr. Vasudev Gowda and Madam Swati to come over.
Good evening to all. Dignitaries on the dais, Sri Vikrant Velagol, Honorable Judge Jakati sir, members of the Managing Committee of the Association, all the judicial officers officiating in Mangalore, and my dear friends of the Mangalore Bar Association, prosecutors, all the invitees, and all men and women who have gathered here. Now today we are celebrating the annual day after a few years, 2 years of inaction because of COVID. Perhaps this year we had very wonderful occasion to get into our usual practice of law, and also along with that we had great opportunity of celebrate great many things with the cooperation of all the members of the Bar Association and the guidance of the judicial officers. From the Managing Committee of the Mangalore Bar Association, as the President, I take this opportunity to thank everybody for all the cooperation throughout the year which you have provided us to make the year very successful. And we are hoping that the coming year, which will be within our term, we will be doing more positive things, and we will try to achieve a lot of things which we are dreaming of, and with your cooperation, definitely all the dreams may become true within the next 12 months. And at this juncture, today we are also witnessing that two of the judicial officers are going away from us. On behalf of the association, I thank both of them, and also we are happy that though Madam Shilpa is going, 2 more Shilpas are coming. They will be officiating in magistrate courts. Both of them are Shilpas. So some sort of compensation is being done by the name. So we hope that the coming days will be greater in your career, and you'll achieve great success in the places where you go for work in future. And today, to end all the good things, we had Mr. Huilagol, who dealt with the tough topic of judicial review, that too in the evening, in spite of several distractions, a complicated subject covering all the historical events which developed the concept of judicial review, and also recent matters which have come up before the courts, which give us some idea about the judicial review, how it is done, what is the usefulness of judicial review. It has been a wonderful learning process for us. Thank you, sir. And I thank all the members of the Mangalore Bar Association for being present here, silently listening to the great lecture and participating in every event which has culminated in today's annual day. Thank you very much. And if I have left somebody to thank for the cooperation, please excuse me. I thank everybody from my heart. Thank you very much.
ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ವಾರ್ಷಿಕ ದಿನಾಚರಣೆಗೆ ಮುಖ್ಯ ಅತಿಥಿಯಾಗಿ ಬಂದಂತಹ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಹಿರಿಯ ವಕೀಲರಾದಂತಹ ಶ್ರೀ ವಿಕ್ರಮ್ ಹುಯಿಲಗೋಲ್ ಅವರಿಗೆ ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಪ್ರೀತಿಯ ಧನ್ಯವಾದವನ್ನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಧನ್ಯವಾದಗಳು ಸರ್. ಅವರಿಗೆ ನಮ್ಮ ಅಧ್ಯಕ್ಷರಾದಂಥ ಶ್ರೀ ಪೃಥ್ವಿರಾಜ್ ರೈ ಅವರು ಗೌರವ ಕಾಣಿಕೆಯನ್ನು ನೀಡಬೇಕು ಅಂತೇಳಿ ಕೇಳಿಕೊಳ್ತಾ ಇದ್ದೇನೆ. ಧನ್ಯವಾದಗಳು ಸರ್. ಅದೇ ರೀತಿಯಲ್ಲಿ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರಾಗಿರುವಂತಹ ಶ್ರೀ ಬಿ ಜಕಾತಿ ಅವರಿಗೆ ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಪ್ರೀತಿಯಿಂದ ಧನ್ಯವಾದವನ್ನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಅವರಿಗೂ ಕೂಡ ನಮ್ಮ ಅಧ್ಯಕ್ಷರಾದಂಥ ಪೃಥ್ವಿರಾಜ್ ರೈ ಅವರು ನೆನಪಿನ ಕಾಣಿಕೆ ನೀಡಬೇಕು ಅಂತೇಳಿ ಕೇಳಿಕೊಳ್ತೇವೆ. ಹಾಗೆ ಇವತ್ತಿನ ವಾರ್ಷಿಕ ದಿನಾಚರಣೆ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬಂದಂತಹ ಎಲ್ಲ ಹಿರಿಯ ಕಿರಿಯ ವಕೀಲರುಗಳಿಗೆ ಹಾಗೆ ಸರ್ಕಾರಿ ವಕೀಲರುಗಳು, ನ್ಯಾಯಾಲಯದ ಸಿಬ್ಬಂದಿಗಳು, ವಕೀಲರ ಗುಮಾಸ್ತರು, ಅದೇ ರೀತಿಯಲ್ಲಿ ವೇದಿಕೆಯಲ್ಲಿ ಇರುವಂತಹ ಎಲ್ಲ ಗಣ್ಯರು, ವಕೀಲರ ಸಂಘದ ಪದಾಧಿಕಾರಿಗಳು, ಪತ್ರಕರ್ತ ಮಿತ್ರರು, V4 ಚಾನಲ್ ಎಲ್ಲರಿಗೂ ಮತ್ತೊಮ್ಮೆ ಮಗದೊಮ್ಮೆ ಮಂಗಳೂರು ವಕೀಲರ ಸಂಘದ ಪರವಾಗಿ, ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ನಾನು ಪ್ರೀತಿಯಿಂದ ಧನ್ಯವಾದ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ.